Good morning, everybody. Though I am taking the lecture on this particular topic, I also taught the Indian Limitation Act. Therefore, I am asking what is my limitation, because it is started at 12 o'clock. Otherwise, it should not become time barred. That is what, therefore, I am asking the organization whether to complete the topic or whether not to complete the topic. In a lighter mood, my friends. Friends, the topic that has been assigned to me is an appreciation of evidence in civil trial. So there are two aspects which appears from the topic itself. Appreciation of evidence and in civil trial. So civil trial and appreciation of evidence. In fact, the appreciation of evidence comes at the end of the trial. We are starting the subject appreciation of evidence in a civil trial. But this is the correct portion of the subject. Why? There is a combination. Combination which we will consider, as we have already heard about the Civil Procedure Code from my friend Jayabhave sir. My friends, when we talk about the appreciation, the word appreciation, it connotes, though it has not been defined in the Indian Evidence Act, but it connotes to understand. That is according to the Black Loss Dictionary. You may be aware that, well, even Supreme Court says, if a particular word has not been defined, Supreme Court always takes the particular help of the Black Loss Dictionary, not ordinary dictionary. That is meant for the interpretation of certain words. So it contemplates to word the appreciation in legal language, not in any other aspect, that is understand or its significance, and more importantly, the emphasis has been given, that is value of something. So when we use the word in the context of this subject, appreciation of an evidence in a civil trial, in short, what we have to understand is the value of evidence in a civil trial. So therefore, now who should know about the value of the evidence? The value of the evidence has to be considered by the partners in the delivery system, justice delivery system. Who are the partners in justice delivery system? Lawyers and the judges. So lawyer must understand the importance of the particular evidence, that is the value of the evidence, in order to plead his case or so to satisfy the judge that he has proved a particular fact, that is existence or a non-existence of a fact. It's a very subject which take time to understand several particular days, months and years, etc. But we have to understand now it is within a very limited period. So therefore the lawyer must understand the importance of the evidence, that is the value of the evidence, who has to ultimately satisfy the judge that this is the particular evidence which I have brought on record. As a result, I am entitled for the judgment and decree. Conversely, both the parties will be arguing. Conversely, the judge has to understand. Ultimately, judge has to decide it. Judge cannot be Hamlet to be or not to be. It's a very difficult case, I can't decide. He can't say. If he say, I can't decide, better retire. He has to decide. And decide lawfully after understanding the evidence, that is appreciation of evidence. So therefore, my friends, this is what aspect you must bear in mind. You may become judge, so therefore you must be aware of this aspect. So to arrive at a right conclusion, to To deliver a judgment, judge has to understand the value of the evidence, and therefore word use is appreciation of evidence. Value of evidence is an interpretation. If you title the subject, value of the evidence in civil trial, it will be something odd. And therefore that word appreciation of evidence. In short, in a case when evidence says that well, you have to come to a particular, definite, particular assertion of a fact. Entire Evidence Act talks about the fact. If you see the definition of section 3, everything, state of thing, relations of thing, that has been defined fact, or any time the mental condition of a fact. If I say, on a particular day, the climate was cloudy, it's a fact. Particular person was angry. When I asked particular question, professor became angry. It's a question of fact. Lawyer has to first understand what is meant by fact. This is very difficult. Particular person is an adopted child, therefore adopted son, that is a relation, is a question of fact. Suppose in a suit for partition, if anybody claims that yes, I am entitled for the property on equal particular footing of a co-partner because I was adopted. Now if particular ultimately he wants to get a judgment and if the fact was to be disproved, he will have to prove that well, that I am taken in adoption according to the provisions or the rules or the act, according to the Hindu Adoption Act. It becomes. So therefore now, my friends, this is the meaning of particular appreciation and the importance which we are considering or value we are considering. This aspect. Now we will have to go again for this aspect, but before that, my friends, we are considering that well appreciation of evidence in a civil trial. Why this differentiation to be made, we'll consider at the last. Why difference between civil trial and a criminal trial? When we'll see, Evidence Act doesn't say it applies to criminal matters, it doesn't apply only to civil matters. No. Barring certain few sections, particularly from section 24 to section 30, purely applies to the criminal law. Confession, anything, admission. But even otherwise, or from section 54, 55, 56, as regarding the particular character in that full case. Because what is the law? Character is not relevant as far as possible in civil matters. But in criminal matters, everywhere, character is the most important aspect. I am taking point on general statement. In even civil matters also, sometimes the character would become also important aspect. Now we will little bit deviate to some other aspect. And we will start from this wording, that is the civil trial. Because there are two aspects. Appreciation of evidence in a civil trial. What is meant by civil trial? Has it been defined anywhere? Nowhere. So therefore we will have to see the combination regarding this trial and the evidence. One has been, civil trial has been considered or has to be conducted according to the civil procedure code. We just now consider certain part of the pleading. That was only a tip of the iceberg of the CPC. But combination is, for example, I plead. If I come before the court, as example was given, in a suit for partition, if I say plaintiff is entitled for a partition in a suit property as described in the schedule. Suppose the plaintiff comes with that particular case. When we consider the pleading, and one of the questions was asked, what is meant by material fact? I am not trying to commit an encroachment over the lecture of my friend, that is earlier lecture. But here it has got some reference, and what is that? Material fact has also not been defined in the civil procedure code. material fact has a connection with the ultimate relief. If a plaintiff is coming with the case that I am a member of the joint family, this property is owned by the joint family, and that I am entitled for, say, 1/3 share, 1/4 share in the particular property. I demanded the share from my particular brother, who is a karta, but he is not giving me any share, therefore I have come before the court. Several questions will arise when we consider the civil trial. The importance of the pleading and the evidence go is in hand. If the civil pleading is a building, if at all it is a building, civil pleading is the foundation. By carrying out, if the construction is to be carried out, if you have to give the judgment, we have to establish this fact, that is the existence or non-existence of a fact, by leading the evidence. And therefore, if you see the definition, when will I point out? Proved, disproved and not proved has connection with the appreciation of evidence. Unless a particular fact is established and judge comes to a conclusion that yes, particular fact exists or does not exist, that if particular fact does not exist, he will say, I am dismissing the suit. And therefore, care has to be taken in the pleading and the evidence. That is what the combination. If I come with a case before the court saying that the plaintiff is a member of the joint family, he has got a share, he is entitled for that share has been denied, very general pleading. Question arises, if you are claiming share, what is the principle in a suit for partition? There is a relationship of a co-ownership. That means you have got a plaintiff has got a pre-existing right. Unless I have got a pre-existing right, how can I claim the share? I can't claim the share. So I have to establish that I have got a share. For that purpose, you have to plead and you have to point out the nature of the property. I am talking about the Hindus. That is Hindu law. Don't take it otherwise. Otherwise, tomorrow there will be morcha. Kanetkar is speaking on the casteism. That is not the case. My friends, what is the nature of the property has to be pleaded. As we know, ancestral property, where the concept is of a co-parcenary, right is governed by Section 6 of the Hindu Succession Act on the doctrine of survivorship. But the property is not ancestral. If the property is self-acquired property, person doesn't get a right by birth. Survivorship, even the child in the womb of the mother, he gets a share. Law has gone to such an extent in that case. Then self-acquired property means what? Again you have to explain this and evidence is to be given to establish the fact. Suppose take his case is, and there where we commit a mistake pleading and leading the evidence. Suppose contention is the property is self-acquired property. We have to mention. If we have not mentioned in the pleading, there is no foundation. Just see how you get share. No existence of a share. Fact of getting share doesn't exist. I will dismiss the suit. Suppose you contention that well, property is a joint family property. Without mentioning ancestral or self-acquired, that is co-parcenary property or this. And if suppose a woman is filing, the daughter is filing suit after 2005, that is particularly 9th September in that full case, she has been included as a co-parcener. But take example, the property in the hands of grandfather was itself a self-acquired property. He executed a family arrangement between his sons and property was given to F. And F has 3 sons and 1 daughter. F executed a gift deed in favor of both the sons didn't give anything to the daughter. Daughter files a suit for partition. And if the lawyer drafts it without understanding the concept of these intricacies in that full case, whether she will be entitled for a share. Whether she will be entitled for a share. No. Property in the hands of father F, which came from G, that is grandfather, which was his self-acquired property, that became self-acquired property by father, Karta, even otherwise, has a right to give the property in his lifetime. Daughter cannot grumble. Because if father would have died without making any will, intested, daughter would have got the share. See the importance of the pleading. Or if you say, at the time of evidence now come to know, plaintiff, that the property was purchased, defense comes by a particular person which is as a separate property. If you read Mullah on Hindu law, you will find even a member, a co-personary can have his separate property which he has purchased, and suppose a share is claimed in that property, Lord Heavenly, you can't claim. See importance of pleading, and then I will go immediately, because though you may not ask me, but later on if I take your time, certain students will come before, lawyers will come before. यांना कोणी बोलवलं? 2-2 तास बोलतायत. That speaking for last 2 hours. So I know my limits in that full case. So point which I am driving at home, my friends, is then we have to make out a case. Suppose that property was thrown in the common hodgepodge. There is one used by Hindu, Mullah, Hindu law. Property thrown in the common hodgepodge, that is otherwise known, word used by the Supreme Court is a blending theory. But if your say contention is that the property was purchased either with the funds of the joint family or purchased separately but blended in the joint family, person gets a share in the property. Therefore, I was telling the importance of a pleading, not merely rules. And the question was rightly asked, what is mean by material fact? Now you will understand what is mean by material fact. You have to make out a case connected with the relief which you are asking. My friends, therefore, coming back to it, therefore come back again, civil trial. What is mean by civil trial? Whether it starts from filing the suit? No. If you read section 26 of the Civil Procedure Code, when the particular case starts, when the plaint is presented to the court, till then it is not used the word suit. Section 26 is to be read with order 4, which takes plaint presented. So the civil suits or civil proceeding will start by presentation of plaint. After it is examined whether as per rules, as per order 4, once it is registered, which is called as a suit register, it becomes a suit. Till then it is not even a suit. Till then it is a plaint. Whether plaint has been defined? Plaint has not been defined. Whether suit has been defined? Not defined. This is what lawyer always go on making the search. And always the questions come in the mind. Why and how? Just like a small child always asks, Baba हे असं का? काही वेळेला आपण उत्तर देऊ शकतो. Sometimes we are able to give. Sometimes very difficult. We say, no, gapas. This is what the position, my friends. So therefore, civil trial, the word trial has been used. So civil trial, which according to me in that full case, the very basis, so far as today's subject, plus the appreciation of evidence, then the civil trial, my friends, according to me that well, starts when the issues are complete. When amendment came in Order 6 Rule 17 CPC, what did amendment came? Regarding bar of the or prohibition to make an amendment. What is the amendment Order 6 Rule 17? It has got, therefore now you will understand, the word trial has also not been defined. But Supreme Court has given one judgment on this point, 2, 3 judgments. Order 6, Rule 17 says that, well, no amendment shall be allowed when the trial starts, unless some due diligence is explained. Again, what trial has not been explained. And therefore, Supreme Court interprets, after framing of the issues, what is the next stage? Evidence. Trial starts. And then in that case, amendment is prohibited. You can't make an amendment unless you make out a case of a due diligence. Why I could not make? या कोविड नंतर आता सगळ्यांचे अमेंडमेंट यायला लागल्यात, इव्हन ट्रायलला. कोविडमध्ये आम्ही काही करू शकलो नाही. वी कुड नॉट डू एनिथिंग. That is what the aspect is taken. Apart from that, whether it will be due diligence or not, make out a search. There is a judgment of the Supreme Court. My friends, therefore, question is in that case, trial, after framing of the issue start. Then what is the next scheme? When trial starts. Trial means actual conduct of the civil suit. Civil suit ultimately to be taken to the logical end, it is to be conducted as a trial. Means what? Facts are to be proved. See combination now. Facts are to be proved. What is meant by fact to be proved? Particular fact exists. Just I gave an example just now. Or I will say, suit is filed for damages on the ground of defamation. And in the defamation, the case is that, well, certain article has been written, published. It's a case under what particular law? Suit for defamation, damages is filed. Under which law? Tort. You must be confident. Judges पुढे भांडता का नाही? Tort. Word use is libel. Libel, slander. Libel, certain publication. Now the plaintiff files a suit for the damages on the ground of particular defamation. The other side will come, he says that, well, my reputation has been damaged, etc. Defendant will say that, well, no, yes, I have stated, I have published, because it is truth. It is for the public good. It is for the public interest. I have published it. But whether it amounts to a defamation, whether it amounts to libel, fact is to be proved. That is evidence to start. Just like in partition suit I told you. So therefore in that case, evidence means to ascertain the facts. The word evidence is a Latin word, my friends. We have taken that, we have borrowed from that. In fact, it is drafted by the Britishers only in that case. So evidence means to ascertain a particular fact, to come to a definite conclusion. So who has to bring the evidence on the record? The parties. Court cannot. So evidence is to be brought on record, that is some material to ultimately prove the existence or non-existence of fact, that is the evidence. And if the fact exists, it is said to be proved. Fact doesn't exist, it is disproved, that is the appreciation. In short, I told you that. If you ask me to talk about 8 days, 10 days. If you ask me about talk 10 minutes, 10 minutes. It's a subject which goes to the very root as regards trial. Sometimes the lawyers are under wrong impression that the Evidence Act may be required only in trials, in the civil court, trial court. No. It also requires in case of High Court, Supreme Court. If you talk about the estoppel, and if you talk about a doctrine of election, the estoppel is a part of the estoppel is one of the species of doctrine of election. What is meant by doctrine of election? I was other day arguing. Court asked me, Mr. Kanetkar, please explain me. What is meant by the doctrine of election? How it is connected with the trial? Just now Jai Bhave sir pointed out. What he pointed out? Alternative reliefs can be claimed. I will give an example and you will understand it. No doubt you can make alternative claim, rightly stated. But when you go for a trial, civil trial, you have to elect it. If I say, I am the owner of the property, declare that I am the owner of the property. Second prayer, it may kindly be declared that the plaintiff has easementary rights over the property which is adjacent. Inconsistent. You have prayed it. But doctrine. What is the principle in case of easementary rights? You are not the owner of that property. You enjoy certain rights over the property of somebody else. And if you say that I am the owner of that property, where is the question of easement? So when you go for a trial, you have to elect something. That is the doctrine of election, which is also a part of sometimes estoppel. So my friend, I was talking about the trial. Now according to the civil procedure code, see the combination. When the trial starts, after framing of the issues, order 18 of the civil procedure code. This combination with Indian Evidence Act. Order 18 talks about the trial, no doubt. But how it is a combination, I will tell you now. Order 18 contemplates that well. Party, that is, it doesn't say who has to start the evidence first. In this case, which evidence would come? In a trial, chief examination, cross-examination, re-examination. Chief examination, cross-examination, re-examination is not covered by Civil Procedure Code. It is covered by Chapter 10 of the Indian Evidence Act, right from Section 135 to 138 and some other sections. Section 135 contemplates order of the particular examinations would be governed by the practitioner as per the law. Section 137 of the Indian Evidence Act contemplates party witness will be first chief examined, then cross-examined, and then re-examined. What is meant by chief examination? The person who calls his own witness, his examination is to be taken, is the chief examination. Adverse party takes a cross-examination, and if there is some ambiguity, the person who called this particular witness takes a re-examination. This is how they want. So in a trial, these examinations comes. So evidence is of two types. What are these two types? Generally two types, as defined in Section 3. Now we are talking about the trial now. So unless we consider trial, bringing evidence on the record, we can't reach to that goal of appreciation of evidence. And therefore, my friends, when trial, when we have to see evidence, it's of two types, which are oral evidence and documentary evidence. So oral evidence is also governed by the particular, what we talk about, the Indian Evidence Act, that is the combination. But trial, who has to start first? Again, there is a combination between Civil Procedure Code, Order 18, and Section 101 and 102 of the Evidence Act. 101 and 102 talk about burden of proof. Therefore, Order 18 starts that way. Party beginning, it doesn't use the word plaintiff. It doesn't use the word defendant. Party beginning will state his case. That is the chief examination. Then where is the question of burden of proof? Section 101 of Evidence Act talks about burden of proof as per the pleading. If I claim certain reliefs in my pleading, as per Section 101, burden lies on the basis of pleading. But 102 talks about burden of proof. If no evidence is given by either party, who would fail? On that person burden of proof lies. See, Indian evidence had to be learned by heart. I say, Civil Procedure Code and Evidence Act in civil trial, Criminal Procedure Code and Evidence Act in criminal trial is nothing but Gita, just like which Lord Krishna told to that Arjuna like this. If you want to conduct the trial perfectly and correctly, CPC and the Evidence Act must be on tip of tongue. Tip of your tongue says, at least you must understand the principles about it. So I was talking about the evidence, two types, oral evidence and documentary evidence. Oral evidence again governed by the particular Indian Evidence Act. But Order 18 Civil Procedure Code says, in that full case, party beginning will lead his case, then other side will lead his case, and in that full case, after this evidence is given by the other side, in conclude that plaintiff or may other party beginning. I was on the point of that, well, sometimes this party beginning and concept of burden proof, how it is to be taken into consideration. I will give one example. Those who will be practicing in banking, DRT must be knowing that promissory note, which is under the Negotiable Instrument Act. Suppose a promissory note has been there, no defense, amount has to be paid. But take example, the defendant says that promissory note was got obtained from me by fraud, by undue influence. Suppose no evidence is given by the plaintiff, no evidence is given by the defendant. Who would fail? Who would fail? Defendant. Because promissory note in negotiable instrument, conclusive proof, but he gives the evidence on fraud or undue influence. In case of undue influence, we'll have to consider the contract act, what it contemplates. Accordingly, pleading has to be done, evidence has to be given. If he says, daughter says, promissory note was got executed from me by my father. There is a case of undue influence, might be a case of undue influence. Employer and employee, there may be a case of undue influence. That is what pleading, and then proof would have to come. So according to me, my friends, in that full case, that pleading and that evidence, that provisions, it's a combination, goes in hand in hand. When I draft a plaint, I am not boasting myself. I first see what is the evidence with us. What is the documentary evidence with us? If this particular fact there is no documentary evidence, who is the witness for us? This has to be taken into consideration while pleading it. So my friend, I was saying, a trial. So chief examination is to be given. Then in that case, again a combination. Section 59 of the Indian Evidence Act, Chapter 4, what it contemplates? All facts to be proved by oral evidence except document. All are rider parat. Rider ke? Section 60 says, if it is a oral evidence, it must be direct. What does it mean? It must be direct. What does it mean? It must be direct, that means related to the senses. If it I see in my own eyes, you have to examine that person. In criminal trial, most important. You always say eyewitness. See how it is connected with the appreciation of evidence in civil as well as criminal trial. If I say I have heard it, suppose there is a marriage petition ground of cruelty. I was conducting one case wherein the witness said that, well, the other couple was residing on the other side. And the husband and the mother-in-law, I am shivered, my friends. I conducted the case. I wanted to retire, but because of that lady, I conducted the matter. The whole night they were beating that girl, which ultimately in that case was required to remove in the hospital. The couple which has went, because there was only wooden partition, they say we're here that well. She was screaming, she was shouting. When they told, evidence must be direct. This is what we have to consider, how to establish a fact, how to show that well fact exists, that is cruelty. It may be mental cruelty, it will may be physical cruelty. We have to understand this. If wife is always giving a threat that if you will not bring me that sari, I will commit a suicide. I will jump from the terrace. It's a cruelty. Fact has to be proved. Or a husband says every time, that your friend, what you are doing with that friend, always alleging the bad character, is a cruelty. But that has to be proved. If it is between only two, between the four walls, it has to be proved. The judge has to appreciate which evidence is to be accepted. Appreciation of evidence. Husband says, you must have read in cross-examination, old case when that case, that Sarada's case. All courts particular convicted him, acquitted by the Supreme Court. Appreciation of even beyond reasonable doubt. See, in civil trial, everything would have been accepted. Not accepted in criminal trial. My friends, therefore, you have to understand that well. So I was on the point of evidence, oral as well as documentary evidence. Now we have to consider the documentary evidence, again the principles, and you have to remember that well. Documentary evidence in that case, my friends, Section 61 evidence Act says, all documents may be proved either by primary evidence or secondary evidence. We have to understand what is meant by primary evidence and secondary evidence. Primary evidence has been defined in Section 62, that is the document itself, original document. If your client has filed a suit for possession on the basis of a title that is a document of a sale deed, if you want to prove the existence of the ownership, that is the title, what will have to be done? If you say that, yes, I am the owner, court will throw your plaint. Section 59, all facts to be proved by oral evidence except document. Section 61, primary or secondary evidence. And then in that case, Section 62 says primary. Section 64 says no evidence will be given or accepted unless permitted hereinafter. Section 63 defines what is meant by secondary evidence. Section 65 defines when evidence, secondary evidence can be given. Unless you establish a fact that the primary is lost, primary evidence is damaged, primary evidence is not available with me, then you are permitted to give a secondary evidence. And if you do not follow this procedure, you will not be able to show that the fact is proved. See the combination in CPC and the Particular Evidence Act. Trial. So when we talk about the evidence, my friends, that is, civil trial means oral evidence, actual conducting of a trial which we conduct in the court, not we see on the serials in the TV or in movies. Somebody comes and says, "Mujhe kuch कहना है." Such is not permitted by Evidence Act, not permitted by this. My friends, some students are carried away. In one particular case, when came to me, sir, I wanted to say something about that. But don't go. He will say, you are junior of whom? He said, Kanetkar. Then whether Kanetkar understands the Evidence Act or not. Very activist. No, I want to say something in this case. But don't go. If you are activist, the coat utaro, bahar jao, kuch bhi bolo. Don't tell my name that I am this junior of Kanetkar. My friends, this is the civil trial in combination. So now therefore I was telling that, well, trial means actually conducting the trial. That conducting the trial, that is chief examination, cross-examination and proving the facts. There is a difference between evidence and proof. You will say, sir, again what happened? I am not saying Indian Evidence Act specifically says. When the parties are required to bring the evidence on the record, even if you produce in a suit for possession title the sale deed, you say that, yes, now suit must be in my favor. You have not proved the document. Then what is to be proved? What section 5960 says? 5960. All facts except document and that is the contents of the document. Now it is a very sometimes a particular case where situation very bad. Section 91 and 92 of the Evidence Act says, when there is a document, oral evidence is not permitted. Then what is mean by contents of document to be proved? Dilemma. Sometimes for the lawyer becomes Hamlet. What to do? Contents of document means you have to again into chief examination. Document also is to be proved. What is to be proved? Execution is to be proved. Execution of a document itself is a question of fact. We say, Baba, you ask the question in the chief examination. You ask the question, yes, whose handwriting is there? Yes, he said. Do you know that? Well, yes, I identify it. Who has signed it? So and so. How you say? It was signed in my presence. What you have proved? Execution of a document is proved. So execution of a document is to be proved again by oral evidence. So that is the combination in section 59, 60, 62. The entire particular chapter 4 and chapter 5 of the Indian Evidence Act has to be learned by heart. Has to be learned by heart. There is no shortcut, according to me. Nowadays everybody talks about shortcut. So tell me within 10 minutes. No, I say no. This is not the subject which can be taught to the team. I even tell to the judge also. Of course in sophisticated language. If the judge say, Kanetkar, I have given you 15 minutes, I adjourn the matter. I will not be able to complete the matter. It is such a vast matter within 15 minutes. But at least now after this court says, yes, all right. I will give you time, then you argue on September. This is what case is. Don't go to the shortcut. If you want to see the particular, the intricacies of this, then you have to see. And therefore now come the particular, I told you a trial. So evidence is to be laid. Who has to bring the evidence on the record? Both the parties have to bring the evidence on the record. That is called a material on the record. And I was telling you difference between evidence and proof. Once a particular evidence is fact is established, it becomes a proof. Till then it is only evidence. When for example, I say, I have got a share in the property because I am one of the co-parsoner, specific pleading. Property was held by grandfather. Then it came to the hands of father and now it has come into 3 brothers. If he denied it, we say that, well, this is the particular and this is the documentary evidence and this is etc. Fact is established. The only question, so fact that it is a property, nature of property, is an ancestral property, has been proved. Then what comes next? Rule of survivorship under section 6 of the Hindu Succession Act. We are considering the backgrounds of appreciation of evidence. Law comes. Therefore you have pleaded, thus sir, I am the member of the joint family, I am one of the co-parsoner. I get a right by birth. And then I say, my right has been denied. The question, if I have to bring out evidence, or at no time there was any partition. You have to take care, my friends. When you take the instruction, suppose in Hindu law, oral partition is permissible. In Muslims, the oral partition is not permissible. They say hibba. And they particular execute a document that has to be proved. That is also sometimes oral may be there. They call hibba. And now in Hindus, oral partition is permissible. But that fact has to be proved. Now suppose defendant says, sir, partition has already taken place. It had done before 15 years back. If the fact was there, if I come to the knowledge, you have to make amendment. You have to say, not a single share has been given to me. So if that partition is there, that partition is not binding me. See immediately combination, civil procedure and then. But that is not sufficient. You have to say, you have to challenge that partition. Otherwise, Supreme Court says that, well, once partition has taken place, you cannot reopen it unless the partition has taken place because of the fraud. Total exclusion. So you will have to make a pleading that yes, it appears that dependence of partition has taken place. Then in that particular case, that partition was fraudulent. I was not aware or I was minor. And therefore, reopen the partition, that prayer will have to be made. This is the combination. I started with this. When we talk about the appreciation of evidence in a civil trial, this is what? Pleading evidence. Pleading evidence. And then I establish the fact, it becomes a proof. Till then, it is not a proof. It is only a piece of paper. Even that cell deed is a piece of paper. Unless it is, and that is what we say, once it is proved, we say it is exhibited. This is what, my friends, we have to consider all these particular aspects. So therefore, I was telling you about the combination regarding the civil, when we talk about civil trial, CPC and Evidence Act. One more aspect need to be taken that well. So in the light of these, when word used is appreciation of evidence, nowhere Evidence Act contemplates. Nowhere Evidence Act contemplates. Mathematically, you must prove 100%. Even in criminal trial also not. What it contemplates, therefore we have to go to, before we go to the appreciation of evidence, we will have to go to find out what is the definition of proved, disproved and not proved. The word proved contemplates when considering the material on record and matter before it. I will pause here, stop here for a moment, and then I will complete these. Matter before it means considering the fact in issue. You must bring the evidence on the record, establish existence or a non-existence of a fact as regard fact in issue. You have brought several evidence on the record, but it is not related to the fact in issue. Take example in a suit for partition. If the dispute is, one admitted is, plaintiff says that the property was self-acquired property of the father. He died intestate. Therefore, matter is to be partitioned to take place according to the rule of succession, that is section 8 of the Hindu Succession Act. And in that case, everybody gets equal share. Even prior to 2005 Act, daughter also used to get equal share if the succession goes under section 8 of the Hindu Succession Act. If that is the case. Now in that case, this is the case, and he says, I have got a share, equal share, because father died intestate. Defendant comes, files a written statement, denies it and says, no, it's a fact that the property, that is the flat, is the self-acquired property of the father. But father has executed a will in my favor. Therefore, you have no any share. Now, on whom the burden of proof would lie? In this case, C combination. On whom the burden of proof would lie? Section 102, I told you, Indian Evidence Act. That is as per the pleading. 102 says, if either party does not give any evidence, who would fail? Burden of proof lies on that person. If no evidence is given, who would fail? Defendant would fail. Property is self-acquired. His contention, father died intestate, defense of the defendant that there is a will. Who has to prove the will? Defendant has to prove the will. But then if the will is to be proved, you have to go under section 68 of the Evidence Act. What is that mandatory provision? Which deviates from section 67. Section 67, normal course evidence, how a particular document or is to be proved. Signature, contents of document. But which I say that well, execution is proved, then contents will stand admitted unless the case is fraud. Yes, signature is of a father, but the contents are false. Then that kind of evidence can be given by the other side. Section 68, if the will is to be proved, what it contemplates? What is the requirement of the will? Section 63 of the Indian Succession Act. What is the requirement? See, several combination of laws. The will must be signed and attested by two witnesses. Section 68 says, even if will is registered, says that unless one of the attesting witnesses is examined in the open court, will is not proved. Will is not said to have been proved unless one of the attesting witness, who says that, well, yes, I am one of the attesting witness. I knew the testator. I saw him signing in my presence. I signed in his presence. That is what the requirement of section 63. That has to be read with section 68 of the Indian Evidence Act. So till then will is not proved. And if the will is not proved, plaintiff must succeed. Will is proved, plaintiff is thrown out of the court. Because admittedly property is self-acquired property. Father had right to execute the will. I think several things I have pointed out within a short period when we will go for appreciation of evidence. That will be a sort of a conclusion in there. But along with this, and then I will come back to the, again, I have not forgotten, though my age is there, but I still remember. I have kept that particular definition of proved incomplete. Now my friends, not only while appreciation of evidence, I was telling to that, well, the fact before it, we have to go to the section 5 of the Indian Evidence Act. What is meant by fact in issue? Both applicable to the civil trial as well as criminal trial. When the issues are framed by the court, in this, at the last example I have given, what will be the issues framed by the court? Does the plaintiff prove that the property is self-acquired property of the father? Does the defendant prove that the father executed a will in the favor of the defendant? Now these are the fact in issue. So evidence has to be brought on the record according to the fact in issue. This is most important, my friends. But, my friends, judge is not a computer. We may be knowing computer. आमच्या पिढीला तर तोही माहित नाही, computer तोही माहित नाही आम्हाला. But still, other things required. It's not only the evidence, oral evidence, and the particular documentary evidence, which is to be considered at the time whether particular fact exists or does not exist. There are other aspects also there. Or even if a particular document is proved, I will give one example, and then you will know where I am taking you. Suppose the case of the plaintiff is that suit is regarding possession and defendant is trying to take possession. He asks an injunction. The plaintiff comes to the case, there is an agreement to sell in which possession has been given to me as a part performance. What is mean by part performance? What is mean by part performance? Section 53A of the Transfer of Property Act. When the possession has been given at the time of agreement, even original owner cannot seek the possession. That is called doctrine of part performance. 53A has got a higher value. If you read the search and read the judgments of the Supreme Court, you will find that, well, possession is protected, even if suit for specific performance has not been filed in time. This is what the particular ratio as on today. Coming back to the case. But now I will take you this aspect and then another aspect. So I consider that, well, fact in issue. Secondly, in that where I am taking you, but take example, this agreement to sell is not on proper stamp. It is not registered. Whether document is admissible? No. So when you are trying to prove a fact, existence of a fact or a non-existence of a fact, defendant would say the document itself is not admissible. Though it is my sign, document itself is not admissible because it is compulsory required to be registered. As per amendment in the Transfer of Property Act 2001, read with section 17 of the Indian Registration Act. The document has no value. We consider appreciation means what? value of the evidence. So that particular document itself is not admissible. No effect. Whether fact exists? No. So you can't get the benefit of doctrine of part performance. This is the meaning of it. So admissibility, non-admissibility of the document is also required to be taken into consideration while appreciation of evidence. Whether a document is proved, because we are what we are arguing. I have established the fact, so particular fact exists. This fact doesn't exist. So that means it is disproved. Defendant will say this fact is disproved. That is existence of a fact that he is in possession by a doctrine of part performance. I would say, but court will say, yes, we have not proved it. So fact doesn't exist. So therefore, when we will consider ultimate aspect, to that effect we will have to take into consideration. So my friends, I was contemplating that well. We have to consider fact and issue in that case, admissibility of the document according to various laws, etc. And then we have to consider, I was telling you, am I to stop? No. Somebody comes here, I think that I am required to stop. Sorry, my friends, completely. Then comes my question, my friends. There is some another aspect. Before we go to the appreciation, because I am trying to lay down several parameters so that you will easily understand what is meant by appreciation of evidence. That is my endeavor and attempt. I will give one more example, that is regarding 2-3 examples. Example in a sense, facets which are must to be taken into consideration in civil trial as well as criminal trial. Competency of the witness or creditability of the witness. This aspect. And secondly, certain fact cannot be proved by either parties. Then there is a section 4 in the Indian Evidence Act. What is that? Section 4 contemplates whenever the Evidence Act lays down that a fact exists, that is by way of a presumption. As laid down of the Indian Evidence Act, court may presume that a particular fact exists. Clause B, section 4 says, whenever it is directed by the Evidence Act, particular fact exists, then court has to presume that fact exists. And clause C says, if as directed as per the Evidence Act, particular fact is a conclusive proof, then the court has to hold that fact exists. And no evidence will be allowed to be, no permission will be allowed to be given to other side, even to lead the evidence. I will start from last. Conclusive proof. What we are doing it, my friends, we are appreciation of evidence, establishing particular fact exists or does not exist. For which purpose we have seen, we are required to prove the fact by oral evidence as well as documentary evidence. So it has to be proved by evidence. But section 4 says there are certain presumptions. No evidence is necessary. Court has to presume. And my friends, any lawyer must concentrate heavily on section 4, because sometimes question arises, we are not able to prove a particular fact. We have to see whether we can go under any presumption as such. What was the last? Conclusive proof. Take example, my friend, section 112 of the Evidence Act. What is the presumption? If the child has been begotten during the marriage, within the period of 280 to conceive the child, it's a conclusive proof that the child belongs to the couple. Even if something might have happened outside the door, but still marriage continues, relations continues, child has begotten within 280 days, it's a conclusive proof. Company is registered before the registrar of the firm. Cooperative society is registered before the registrar of the court. If somebody comes, defendant comes, say that, no, you are not registered, whether you will be allowed to say so? No. Unless you say that, well, that company itself is a fraudulent company. But it will have to be shown, that is called as a rebuttal evidence. Normal course, court will not allow you to give any evidence. Court will say, no, mouth is shut up. It's a conclusive proof. Original is lost, it is proved, original document. Plaintiff proved the certified copy under section 79 of the Indian Evidence Act. Court has to presume that is a admissible and a legal and valid document. Because certified copy is permissible according to the section 63 or section 65 of the Indian Evidence Act. Fact has to be accepted as a proof. There is a presumption. Map published by the corporation, government. You see a particular map published by the government. It has to be accepted. Conclusive proof, or in any case, mandatory, accept that particular position. It was framed. So my friend, we have to consider this presumption from section 79 to even the, take example section 108 of the Evidence Act. If particular person is not seen for a period of 7 years, wife comes and says that, well, I have not seen my husband for last 7 years, he has died. There is a presumption he has died. That is called as a civil death. My friends, I am told that is also necessary for the purposes of appreciation of evidence. Once I start, no water. After over, give me 1 glass water. Let us stop here just now. Let me complete other. Should I continue? If anybody is hungry, he is taking care of you. He says that, well, the participants may be hungry. If you are hungry, so should I continue? With your permission and with your consent, so trial will go on now. My friends, therefore, on which point? Conclusive proof, I was saying, certified copy. So that is law permits. 108 says that if person is not heard of 7 years, law presumes that he is dead. It is a civil death. See, there are certain presumptions. So in such case, if the wife wants to make certain claim, and she goes in the court of law, she has to simply say, I have not heard for 7 years, for last 7 years about my husband. So therefore he will be declared as a dead. This is what the position is. My friends, therefore, these are presumptions. And the really last aspect. Otherwise you say, for last half an hour you are saying lastly, but I will continue that. I have already told you, creditability and competency of the witness. Very important aspect, and that is why we say, marriage petitions are to be conducted by senior judge. Family courts is established. Earlier it should be heard by district court. Why? It is presumed and sometimes correct also. Judge has to appreciate the evidence. Not only on the basis of these papers. Proved, not proved. Everything is there. But there may be some angle also. And that depends upon the competency of the witness, section 118 of the Evidence Act. And creditability of the witness, the knowledge and experience of the judge. We say so many things that by experience I can tell. I will vow that yes. See, ultimately, when we will see the last definition and conclude within 2-3 minutes about the appreciation of evidence, because I already told you the parameters. Then in that case, it is a matter of inference. When we will see the definition of proved, disproved and not proved, we always draw certain inferences. Sada hai. If joke is cut, we laugh. So nice jokes are cut, I keep quiet. What you will say? Something is wrong with the sir. Either he doesn't understand the joke, or he is mad, or what is something. That is the inference. It is a test of a common prudent man. When we will see the definition of proved, disproved, it is a test of a common prudent man. I am tempted to give example. Suppose that your representative had come in to receive me, And if I say that I came from that distance from the road within 5 seconds, you will not say anything at this time. If you go outside that well, क्या bundle मारता है? See his age, see his weight, and he says he has come in 5 seconds. Test up a common prudent man. Inference is to be drawn. On the basis of knowledge, sometimes may go wrong. And therefore, my wife never takes me to any picture. Reason is, they show humbug things, I say, this is all contrary to the Evidence Act. He said, you are not giving lecture on Evidence Act. Keep quiet. Doesn't suit to me. Where I am sitting and somebody talks about nonsense, I immediately say, no, I can't accept this. Sometimes there are benefits, sometimes there are disadvantages. Apart from that, I was on the point, creditability, his knowledge. I give one example. It happened in my case itself, in a sense, my case means which I was conducting. There was a case of an adultery, my friends. Adultery, and that husband said, I am not boasting, I proved it. Husband says that, well, when I go to the office, that this particular respondent number 2 has been joined in this marriage petition, used to come in the afternoon. And there used to be whatever happens in that case. You know that well, in case of adultery, law says it has to be proved, like criminal trial, beyond reasonable doubt. It's very difficult. In civil trial, it's not mathematical, inferences. Whether, when we'll say probabilities, whether it might have happened or it might not have happened. In medical science, different. Suppose tomorrow I fell somewhere. Somebody may say his sugar has gone down. Somebody may say he has suffered a heart attack. Somebody may say it's what like this is. Several inferences are there, depending upon the facts of each case. So this is the job or record to be done by the lawyer as well as judge, inferences with the experience, good sense, knowledge, considering the facts and issues on the record. Then fortunately for us, they had one child of 6 years that time. Unfortunately for mother and fortunately for the father, the child was very much attached to the father. Child used to go to the school in the morning, used to come about 12:30. And that man used to come about 1:30. Moment he comes, he used to give something and boy was asked to go and play. Forget about study, homework, etc. I said, how to prove it? The husband said that, well, my child will tell. Now you say section 118 of the Evidence Act, competency of the witness. And which starts, even child a competent witness, unless he knows or everything and etc. I took a risk. I examined the child. The judge said, Mr. Kanetkar, you can't examine, child is only of 6 years. I am not boasting, I told the sir, go to the section 118. He said, yes, you can examine. But judge was very nice. He said that, let me confirm it. In the open court, he asked the question. He said that, well, in Marathi I can tell, in English or Hindi, he said, बाबा रे, पाप म्हणजे काय, पुण्य म्हणजे काय, किती चाइल्ड ग्रोन अप होतो बघा, आणि पाप केलं तर काय होतं. That means what is that sin and what is this, and if you commit any sin, who will punish you? He said, sir, मी जर पाप केलं तर मला देव बाप्पा शिक्षा करील. मी जर खरं बोललो, चांगलं बोललो तर मला देव चांगलं ठेवील. Just says Mr. Kanetkar, start asking the questions. The questions ask, तू केव्हा येतो शाळेतनं? When you come from the school? He said, I come about 12:30. Then what do you do? He said that, well, I take my lunch. And then what happens? The respondent 2 was sitting. This uncle comes. Where he comes and sit? He comes and sit in the bedroom of my father and mother. Then what you do? Will you shoot TV? No. The uncle gives me populate, what you say, and he says that, well, go and play. They go. And they say me come out after 1 hour or 2 hours. Evidence was believed. Court held that it is a case of an adultery. Fact of adultery exists. Creditability of the child. This could be done by experience of the judge. The manner in which person is deposing. Manner is, even so many things on your body language. If I am telling lies, I may be shivering. I am telling the truth. I have no any particular fear. I say, yes, it has happened. That gives me courage. That is the experience of a judge for appraisal. So, my friends, what I was pointing out, only pleading, it is must. Evidence, oral, documentary, admissibility, presumption, all. In addition to this, creditability, and this, that means which involve the knowledge and experience of a judge. This is also a parameter for appreciation of evidence. Did you get my point, my friends? This is the appreciation of evidence. And there was sometimes, you must have heard sometimes, you must have read sometimes, what happens? We have heard sometimes, no sir, we argue, sir, don't believe this. Court say, why? Don't believe this particular person. Why? He is an interested witness. What is this concept? To show whether a particular fact exists or not exists. If that particular person, who is the brother of the particular wife, and he tells something, we say he is an interested witness. I told you about the child witness. There are certain witnesses which are chance witness. In election matters, if the concept of a corrupt practice to be proved, while setting aside the election on the point of corrupt practice, and if petitioner examines a particular person, says that, well, yes, I attended that meeting, and in that particular meeting, I was conducting one case in Aurangabad High Court. In an election petition, I was for the respondent. And contention was taken in that particular case, sir, I heard the speech, C, etc., and therefore it is a corrupt practice. I asked him the question. A got-up witness, chance witness, I asked him, from where you come? He said something, yes. 2 minutes. He said, yes, I came from this. What you are doing? I was just going by this side. What you heard? I was just hearing that somebody something going on. I pointed out the court, he is a chance witness. He is not a witness who has attended the meeting for that particular purpose. This is how we have to argue. It has to be appreciated by the judge. This is what, my friends. So, and lastly, certain provisions of the law. And therefore, my friends, in appreciation of evidence in civil trial, proved means definition. I am the last version. Proved means when a particular fact in question, considering the material before it, if the judge believes that fact, fact is said to have been proved. Second aspect, if considering the material on record and the matter in issue, if the judge believes, considering the common test of common prudent man, that particular fact exists, that is the presumption, it is proved. Exactly reverse definition of a disproved. So therefore, my friends, this is what the process goes on. Ultimately, in a civil trial, fact has to be proved in several ways, which I have pointed out. Ultimately, one has to come to conclusion whether fact exists or does not exist. That is the meaning of proved, disproved, and not proved. And therefore, in civil trial, it is always stated that in civil trial, appraisal of evidence is preponderance of probabilities. That remember, my friends. Supreme Court says, on preponderance of probability, no mechanical, no arithmetical, if as per the knowledge given or any other concern, considering the material on the record, judge comes to a conclusion, then he consider, even if 60% fact is proved, preponderance of probabilities, not 100% required to be proved. Same thing in disproved. So this is what may happen. In case of criminal trial, exactly reverse. Strict evidence. And therefore say, the prosecution has to prove the case beyond reasonable doubt. What does it mean? Though it is not today's subject. Beyond reasonable doubt means what? If A is the accused, so it is only A who committed this offense. He killed him, he committed an offense of murder 302. But that is not sufficient for the prosecution. No other person has the chance or any particular this. No other person had done it. That is beyond reasonable doubt. That was argued in Sarada case, which I told you. What was administered to the wife was potassium within the four walls. And the very person was doing the business of selling the potassium. And it was found that well, that what we take that particular rug on ourselves, one poison of left hand was attached to that person and another was not. Means what? It was the case of the prosecution that when the husband gagged the mouth of his wife, putting a pillow on her mouth, she was doing feats like this, man does like this. And that is why there. In fact, prosecution had brought a very nice evidence. All three courts believed it. Unfortunately, Supreme Court doesn't believe it. And says that, well, it is not beyond reasonable doubt. We are giving benefit of doubt. So that is the difference between civil trial and a criminal trial. Sorry, my friends, my particular lecture took little bit time. You have heard me, I think. Thank you, my friends.